With more and more people choosing to live together and not get married, it is important that we dispel the myth that those living together as cohabitees have the same right as those individuals who are married on a separation. If you are not married, claims to finances are limited to property. If the property is not held in joint names, the individual whose name does not appear on the title deed will need to establish an interest in that property, be it by way of contributing towards the deposit, the mortgage repayments, home improvements. Alternatively, a conversation may have been had with the other individual during the course of the relationship in which a common intention is established. If there are children of the relationship, there is scope for further financial orders, be it by way of lump sum, top-up maintenance payments. Of course, it really does depend what finances are available. Sadly, if the relationship has broken down and you're unable to reach a settlement in relation to finances, negotiations and mediation having been unsuccessful, it will be necessary to make an application to the court. If it is necessary to make an application to the court in relation to the property, it is not uncommon for the unsuccessful party to not only bear their own cost of litigation, but the cost too of the successful party, which can turn out to be a very costly exercise. One way to limit any issues further down the line on a breakdown of a relationship is for an agreement to be drawn up at the outset of a relationship or during the course of the relationship, which sets out how the assets are to be distributed on a separation. However, it is important to note if there's any breach to that agreement, it's governed by contract law. If the parties subsequently go on to marry and later get divorced, the matrimonial courts are not bound by the terms of that agreement. They are merely a consideration.